Welcome to Law Subscribed. This is your dedicated news source for all things subscriptions in the law. My name is Matthew Kurbis. I'm the subscription attorney, and I believe subscriptions can help bridge the access to justice gap and incentivize attorneys to modernize and scale their practice like never before. On this show, I interview lawyers ditching the billable hour and experts who can help attorneys move beyond billing time. Thanks to my sponsors, 650 and Gavel. Links to both in the show notes. More on them later, and use the code LAWSUBSCRIBED when signing up. You get 10% off, and it supports the show. The best way to support the show is to share it with someone you know. This podcast is for educational and entertainment purposes only, and nothing said is legal, ethical, or financial advice. Without further delay, here's the episode. Bill Josten, so glad to have you on the Law Subscribe podcast.
It's so great to be here. Thanks so much for the invitation. I'm thrilled.
Well, Bill, I heard you on a Thomson Reuters podcast talk about the 2024 report. And boy, oh boy, did I have to have you on this show right away. But just in case my listeners haven't come across any of your stuff before, go ahead and give yourself a little introduction.
Yeah, so I work for a group called the Thomson Reuters Institute. That is the thought leadership arm of the broader Thomson Reuters enterprise. A lot of people are familiar with Thomson Reuters. That's Westlaw, Practical Law, Reuters News, of course. We have a specific arm that is just geared towards thought leadership, and it serves all of our various customer verticals as well as certain topical areas. And my role within the Institute is I am sort of the global lead for thought leadership content creation and curation geared towards law firms and corporate law departments. So I often tell people, look, if you have a JD or you work for someone with a JD, pretty much any size enterprise or law firm, more or less anywhere in the world, my job is to find thought leadership content for you. So that involves a lot of proprietary research. Being Thomson Reuters, we sit at the intersection of the buy side and the sell side of the legal profession. So we have access to a lot of information. We can pull data directly from financial management systems at law firms. We can look at e-billing data. We can look at dockets data. We look at some litigation analytics data that's sitting in sort of an AI tool that sits on top of Acer and a few other dockets tools. We can pull all of this together and then use that as an evidence-based platform for which to opine on things in the legal market. So essentially, beyond just creating and curating the thought leadership, I do a lot with both the buy side and the sell side of the legal market, where I'm talking to, I'm out at a lot of events. I do probably 12 conferences or more a year. And I think last year I did 45 presentations of some sort, either webinar or conference in person. And then in addition to, some consulting gigs and things like that, but really listening to what the market is talking about, bringing TR's perspective to those conversations in a way that's data-based. I say lawyers are creatures of two things, evidence and precedent. And our data is the evidence. The case studies and the best practices that we see come out of that are the precedent. Lawyers never want to be first. They want to be first to be second, right? So if we can find examples for them to follow, and then also looking in our data and saying, hey, this is something that we see as a reality in our data that the market isn't really talking about. And it's a conversation that we think needs to be happening. So how do we spark that conversation? So it's a lot of work. It's a lot of fun. We've been in incredible demand for as long as the Institute's existed. I've been with the Institute for about 8 years now. I've been with TR for a little over 13. But really since 2020, things have been so dynamic in the market that we've seen consumption of our content just go through the roof. You mentioned the State of the Legal Market report. That's our flagship report. Comes out usually the first or second week of January every year. Never later than the second week of January. It's just a question of when New Year's falls. And then we've got, webinars and live events. You mentioned that you heard our podcast. If I can give a quick plug, Thomson Reuters Institute Insights. Go out, find it on your favorite podcast platform. Reach out, let me know what you think. And I'm glad that you found it worthwhile. But just a ton of different things that we're doing to get information out there. People are so hungry for best practices, to know what are the things that they should be doing, what are the models that they should be following. And we get into that in a little bit in the State of the Market report. And that's a lot of what I do on a day-to-day basis is what are we learning and what do we know based on data, not just anecdote, not just supposition, and not coming from it. And not coming at it from the perspective of sort of war stories. There's so much in the legal industry that's based off of war stories. The people they practiced a really long time, decided they didn't want to practice anymore. So now they're going out and consulting. And a lot of what they're talking about from consulting is what they did in practice and what they found worked best for them. And that's great. I mean, Those people are brilliant. They've got a ton of experience. We're coming at it from a different perspective because frankly, we don't have, the former managing partner of a major Wall Street firm that is the head of this stuff. I'm the head of this stuff. Sadly, I'm not the former managing partner of a Wall Street law firm. Um, but if we can bring evidence, if we can bring that data where it shows, no, what we're saying here is real. This is research. This is vetted. This is backstop. That becomes very powerful and very compelling because you think about how lawyers think. They want to be able to cite that document. They want to be able to find that case and know, okay, if I make this argument or if I cite this, this is my potential outcome. It's the same thing when we look at business of law principles as well.
So first off, sounds like one of the coolest, most fun jobs that are. That's number one. Number two is I think you dodged a bullet with not being a managing partner at a big Wall Street firm because how many of them are divorced, don't know, who their kids' significant others are or what they're into, they're just not involved with their family at all because of, they're managing this big giant firm. They're billing time. They're managing people's time to make sure the firm is profitable. And to bring it back to the theme of the podcast, which of course is like the billable hour is bad, we should all be doing something different. And the problem with that is, especially in the subscription legal services space, is there's such lack of data. And as
Yeah,
important as data is, I mean, data is more important than it's ever been before in light of generative artificial intelligence, right? And training data and all that. But
for sure.
lawyers do a terrible job managing their data within their own practices, right? Even if evidence is important, you're absolutely right. But like when it comes to data, lawyers, I feel like they treat it kind of like math. It's like, I don't want to think
Yeah,
about math and data. That's why I'm practicing law.
exactly. I went to law school to avoid math. And that's totally true. And I will say, working with a ton of managing partners, there's an evolution happening. They're starting to look at things very differently. I was always told, so I graduated from law school in 2006, and I felt like I was being sold a bill of goods to an extent in law school because we were told you guys are going to be the generation that's going to change the way law is practiced. And I kind of thought, how on earth is that going to work? We're stepping into this pre-structured infrastructure of what it means to practice law. And frankly, big law never really interested me because I like to work very, very quickly. I was a clerk at the Minnesota Court of Appeals. Honest to God, I struggled to make that a 40-hour a week job. I carried a full workload. I did the same thing everybody else was doing. I would see my colleagues that were working, 50, 60 hours a week as a law clerk. And I'm doing my 40, but I'm kind of, by the end of the day on Friday, it's kind of like, all right, what else can I do? How can I work ahead? Like I I I was just very efficient. I got stuff done. And I knew this is not going to translate well in a big law firm where the hours are king. So I've personally never been a huge proponent of the billable hour just because of the way my own practice has worked. But what I didn't realize 15 years ago, a little more than that now, when I was in law school, was we probably are, to an extent at least, the generation that's changing how law is practiced and done. Um, but we had to wait 8 or 10 years until enough of us got into partnership to be able to have influence, right?
Right.
So
Right.
it was the theory was correct. I misunderstood the timing aspect of it,
Right.
but I do see it coming. And I do a lot of events with managing partners and GCs as well because they don't necessarily care as much about the point ones, but they come from a point one mindset. We're seeing a lot more conversations now amongst those leaders, even in the major law departments, the major law firms, where attorney well-being, work-life balance, the hour with a lot of those firms is still king. I mean, for better or worse, the billable hour is the unit of commerce in the legal industry. And there are ways around that. And I think conversations like this, where we're looking at subscription-based things. I did an article last fall, kind of evaluating the pros and cons of subscription-based pricing. I'm a huge fan of subscription-based pricing and other alternative fees. I like to be creative.
And you
You know,
have the benefit of seeing a lot of this data, in particular back to
yeah,
the report, because like I said, the subscription model, while I did have an attorney on the podcast who for 40 years of practicing law never billed his time, he didn't really get into subscription until like the last 10 years or so. So it's really like we're looking at the last maybe 10, maybe 12 years that lawyers have consistently been doing it, but it's so few of us. I mean, there's far more of us now. I think we're approaching 100. We do lack the data. But what you have access to and what you see, I'm curious to know. about, and I'd love the link to the article to share with my audience in the show notes. But what have you seen just in terms of alternative fees in general, whether that's coming from the law firm perspective or from the client side? And there's two types of clients, right? There's institutional clients and there's latent legal market clients. So I don't know if there's a lot of data on latent legal market clients, but so we could focus on institutional clients, what their demands are for alternative fees. Can you share a little bit about that?
Yeah, absolutely. So, I mean, we've seen the concept of an alternative fee arrangement or an AFA. And by the way, I don't include hourly rate discounts in AFAs. I
Neither do
barely,
we.
yeah, I barely consider caps. I don't consider a capped fee to be an AFA. That's just a budget where you can't win. But the concept of AFAs, that wasn't even in the lexicon prior to like 2010. I mean, you started to hear a little bit about it. It really took off between 2010 and 2013. You saw it go from non-existent in 2008 to about 20% of law firm revenues by 2012, 2013. And then it plateaued. It hasn't really diminished in importance. It's just plateaued. And when you look at why, it really becomes a chicken or the egg question. Law firms aren't putting a lot of options out in front of clients. Clients aren't accepting a lot of options. So, and I talk to clients in particular, because really, I mean, the State of the Legal Market report makes this case that we are in a buyer's market. We have been for more than a decade. We are in a buyer's market in the legal market space. Whatever clients dictate, that's what's going to happen. That's just a fact. And I can make that whole argument, but it's in the report. Go download a copy of the report and you can see it all laid out. The case is all there. But clients will say, well, we're really frustrated because our law firms aren't giving us good options for AFAs. We need to get better options for AFAs. So I go over and I have a lot of friends on the pricing side of the legal market. And I say to them, clients are saying, why aren't you giving us better options for AFAs? And the response I get is, as soon as they start agreeing to anything other than billable hour arrangements, we got plenty of ideas. But it's become very common practice now for a lot of these firms that have robust pricing teams and very, very skilled, knowledgeable pricing directors in place. They price everything two ways. This is what the hourly arrangement would be. This is the alternative arrangement. And that could be, we're going to wrap it into a subscription, or we're going to do it fixed fee or phased fee, or we're going to do a collar or whatever. Like, they could do different things. And the client goes, well, okay, if I do this alternative, you'll have to make sure to show me the shadow bills. And shadow bills are probably one of my bigger soapboxes, because if you're a GC that wants to be innovative and wants to be looking at alternative pricing, do not ask for the shadow bill. It is the absolute worst way to drive innovation. And I've used the example before. You and I sit down and we have a conversation and we agree that there's an existential problem for your business. You have a threat that, if not addressed, will tank your business, and you have a $100 billion business. So we say, this seems like about $1 million problem to you. And you go, yep, $1 million feels like the right number to me. So we agree, we're going to just do it. $1 million fixed fee. I go back to my office and I realize, hey, you know what? I'm actually kind of a smart guy. I wonder if I could do these 3 simple things. And I do those 3 simple things and it takes me 15 minutes, but I look at it and I go, wow, that's really good. That might just be the answer. In fact, I think that is the answer. Nobody's ever done this before. It's totally new, but this is the answer to the problem. And I send it over to you and you say, wow, this is the answer to the problem. This is brilliant. This is great. Well, my hourly rate's $1,000 an hour. I did it in 15 minutes. Are you telling me that $1 million problem just became a $250 problem because I happen to find an innovative solution to it? Is that really what we're going to talk about here? And if that's the case, either I'm never working for you again because I'm not getting paid a commensurate rate for the value I'm delivering, or the next time I'm not going to look for that innovative solution that's going to get you the answer. Because, if you have this type of existential problem, and granted, this is an extreme example, right? But if you
Actually,
have
I
this,
don't think so. Because here's the thing. What you just said could have applied at any time in the last 50 years, at any time
oh, for sure.
as long as lawyers have been practicing law. I think generative artificial intelligence highlights this problem significantly. Don't you think?
Oh, absolutely. I mean, so when I say it's extreme, it's not necessarily going to be a 15-minute solution, but a lot of the things that would have been used to churn hours in the past, those are going to be things that are going to be automated into Gen AI relatively quickly. The idea of the robot lawyer, I mean, ultimately maybe, but at TR, we talk about sort of effective generative AI living at the intersection of data technology and expertise. And that expertise element is always going to need to be there in some form, right? I use the example of like when I was a clerk, again, going back to my time as a law clerk, whenever I would have to site check something, I'm doing it in books. Like I learned how to do this all on paper, right? Well, now I have a plugin in Word where click done, right? All my quotes are vetted, my page numbers are checked, my citations are flagged, but I still have to be expert enough to understand what all that means and how to work with it. Like the AI can tell me, hey, this case is overruled. But in my expertise, is it overruled on the point of law that I care about? Or is there a way that I can finesse it that, yes, the case is overruled, but it's still valid for what I'm trying to argue? Or, the fact pattern, like there's an element of expertise that even with the technology we have today, that's still going to be the case in the future, right? It's learning how do we work with it. But the idea that we are going to get more efficient, we're going to find answers more quickly, we're going to find more creative ways to solve problems. Yeah, that's going to happen. It's a question of when, not if. So yeah, we got to learn how to deal with it. And it will impact billing. It's amazing. Right now, I'm already getting questions, and I get it probably once a week, either from an external customer or someone within Thomson Reuters saying, okay, how is generative AI impacting law firm billing? And the truthful answer is today, not much. Soon, a lot.
I'd like to caveat, although I know that there's not data on this, right? Although Bill, I point you to the Law Subscribed podcast, and you can listen
Mhm.
to all the attorneys. Like, there's your data, right? This is part of the reason I have the podcast. I interview lawyers using the subscription model, but I think that for billable firms, not much. For firms that are already leveraging subscriptions and flat fees or a combination of the two, Gen AI is having a massive impact on profitability. I could tell you right now, I'm able to take on way more client work as a subscription attorney because I could get the work done faster without having to hire and scale in that more
Yeah.
traditional way.
Yeah. Well, it is a question of scale, right? Because when you look at major law firms, when I talk about the impact that Gen AI is having today, well, what's the product that's having that type of impact at scale? And there's just not a lot out there yet. There's a lot that's being tested. There's a lot that's being vetted. When you talk to these large law firm managing partners, they're they know that Gen AI is a can't say no proposition, but they're looking at it for internal problems first. So, going back to an example of when I was in practice, it took an hour for me to open a client file. Like I had a client come in for an initial meeting, they signed on the dotted line, they wrote their retainer check. Well, now to have the file quote unquote open in our system was an hour worth of work. I mean, just a ponderous process, completely preposterous. But that's what it was.
Mhm.
Now that's going to be minutes, and most of it's not going to be my problem. I may have to do a little bit of data entry, but the rest of the process of actually opening the file and generating the documents and stuff, that's not necessarily a client facing thing. It's generating correspondence to the court and opposing counsel and assertive rep and that type of stuff. Like it's all stuff you have to do, but it doesn't have to be super time consuming. That's the type of process that they're looking at is, what can we do internally that sort of proves the concept and builds evangelization and builds a level of comfort within the firm. And then we can start to scale and apply those learnings to client facing endeavors.
And to that point, I think for a time, even like implementing AI in these ways that you're saying, and even you talked about on that podcast interview, AI's impact on like analyzing billing and time codes. Now I've already seen some tools that are like, hey, we're a billing and time codes tool for lawyers, and we use AI so you don't have to worry about putting in time, so you're reducing non-billable time. So like all those things that maybe you couldn't build a client for, if you could automate those, if you could use AI, then now you could spend those hours either going to your kids' athletic activities
Yeah.
or billing more time, right? And so I think in the short term, we can see AI still make a billable hours attorney life a little bit easier or allow them to
Yeah.
build more hours. But I think there will be this tipping point, right? Of, well, now tasks that used to take me 10 hours are now taking 10 minutes or less. And so I can't, there might eventually, there's either going to be not enough work, and there could be maybe more work that a client will send you. I've heard, I've read some reports that GCs will like, well, we'll send you more things if it doesn't cost us as much money, right? So like But even you could run that example out. Eventually, they're going to run out of things. There's this latent legal market, right? There's a latent legal market which is pegged at $1 trillion market opportunity by some experts out there worldwide. $1 trillion market opportunity that's not being served right now. So then law firms will move into that. But I think lawyers who stop billing time, leverage these AFAs, and I'm curious to know if you have a data perspective on this, who leverage AFAs and these automations, this Gen AI, they will simply outcompete in terms of pricing certainty. This is in particular the latent legal market, let alone clients, institutional clients who are just sick of billing time. Who cares? No client's going to want to pay $25,000 an hour so that the lawyer still gets $5,000 for a task that used to take 10 hours at $500 an hour, right?
Right.
So is the data directionally showing that this is a likely outcome, or what do you think about that?
Well, for example, in the State of the Legal Market report, we asked cost control is a huge priority, has been for a lot of years, but really coming into sharp focus now for a lot of our corporate clients. And we asked a question of them as part of our data set. We do interviews with about 2,000, between 2,000 and 2,500 corporate GCs globally every year. And these are not this isn't, an email survey. This is on the phone, talking to them for 30 or 60 minutes, 2,500 of these a year. And they're primarily open-ended. Where we're saying, what are your biggest priorities? And then we just take the verbatims, and it's all qualitative. But the thing about qualitative data is if you hear the same thing often enough, the qualitative becomes quantitative, right?
Right.
And we asked them, what are going to be your top cost control strategies in the coming 12 months? And there were a lot that didn't surprise me at all, but two really jumped out at me. One, they specifically said, we intend to push work to lower cost firms. Now, they've talked for years about, consolidating their portfolio and moving work around and whatever. What was different about the way it was phrased this time was the lower cost part. Like, they're being very specific about that. We've always known that was an element of it, but there's also this idea of, well, we're shifting work to the firms where we capture better value. If we're cost effective because there's a better value delivered for the dollar. It doesn't necessarily mean it's the cheapest firm. It's just lower cost of ownership, if you will. But we saw 50% of clients saying that they intend to shift work to lower cost firms. We saw 54% of clients say that they intend to use more AFAs. That number really jumped out at me because frankly, the industry is not that good at it yet. Even though we've been doing it for 15 years now, the industry's just not that good at it because everybody still thinks in terms of point one. There are people that are very, very good at it. The pricing teams at these firms are very sophisticated. They look at great data. They put together really good packages. But where it starts to break down is that there's a certain amount of disconnect between the pricing teams and the attorneys that are actually making the pitch. And then between the attorneys making the pitch and the overall firm and the client. There's a sort of a throughput of education, if you will, that I think is lacking in terms of where the value comes from, how it's going to be advantageous to both sides. We talk a lot. I mean, anybody who's ever been through any kind of sales training has been through some form of what they call a value wedge. The idea of identifying what is unique about your offering that matters to your client, but that your competitors can't replicate on. How can you compete on something other than price? And that's something that I think a lot of law firms struggle with right now. Everybody's really fixated on rates, and that's understandable. If you think back, stepping in the Wayback Machine here, going back to the mid 90s, David Meister's book on managing the professional services firm, where he defined the acronym of the rules of profitability, rates, utilization, leverage, expenses, and speed of billing. Well, what's the very first letter? Rates, right? And you can go back and look at our State of the Legal Market report. I think it was maybe even 2017. We did a look going back through 10 years of data to see what's been driving law firm profitability for this 10 years. Well, it was rates. When I use the rules acronym, I redefine rates to actually be revenue because rates are important, but rates are only important in so much as they drive higher revenue. You have to be driving revenue. I could set my rate at $1 million an hour. Doesn't matter if I can't sell any units, right? If no one hires me.
Even if you do sell units, you got to collect because when you're selling units of time, you have to collect in arrears. You have to do the thing, see how long it takes, and then get paid. Meanwhile, flat fee subscription. And even
Yep.
and I'm in Illinois. We recently changed our ethics rules to allow for flat fees, fixed fees, get to go right into your operating account, paid up front, right?
Yeah.
So, and you probably could have done that before, but now we explicitly allow it, right? So I think there's a move in that direction. But there are two
Yeah.
things I want to highlight based upon what you're saying. One, it goes back to our earlier conversation. One of the first things we talked about, which was you liked to move fast, and it's harder to do that at big, giant lumbering law firms, right? So you've got, I mean, that number that you said is staggering, right? 54% of corporate GCs say AFAs, and moving down market or to lower cost firms, to small, which is probably smaller firms who have the ability to more easily pivot to other alternative fees. When you have a big giant law firm, good luck trying to do that expeditiously. And it also makes me think, and
Yeah.
this is something that I talked about with Damian Reel on episode 55 of the podcast, which was he purported that the first law firms, his prediction was the first law firms to move to alternative fees or to move to pricing certainty for clients will capture more of those clients. And it's going to be harder for the other firms then to come in and compete and try to pull them away at that point. So I'm curious to know your perspective on that. But that is just such an incredible data point of the 54% of GCs that want to do that. And for me, that screams market opportunity for the
Oh,
small law
absolutely.
firms. Huge market
Absolutely.
opportunity.
Absolutely. The only thing I totally agree with how you're paraphrasing Damien there. I completely agree with all that.
When I went solo, I pivoted from mostly litigation to a transactional-only practice. I did not have a database of documents to automate. That's why a business and employment legal document database and automation tool like 650 is super useful. I can rely on the quality of the documents in 650's database since they're putting excellent legal minds to work curating and updating their documents and automations over time. When you're not billing by the hour, outsourcing and efficiency matters, and 650 can help you scale your practice to get high-quality documents drafted in less time. Use the code LAWSUBSCRIBED at 650.com, and when being onboarded to get 10% off. If you're not a business and employment attorney or you have your own documents that you'd prefer to use, then my next sponsor, Gavel, is the automation tool for you. Gavel allows you to build shareable, client-facing workflow and document automations. In other words, Gavel helps you create a legal practice where attorneys can monetize the value they bring clients in productized form and scale via subscriptions and flat fees. Use the code LAWSUBSCRIBED at gavel.io to get 10% off an annual subscription. There's no one right way to automate and scale your practice, but with one or both of my sponsors, 650 and Gavel, you can take your subscription law firm to the next level. Links to both in the show notes. Now back to the show.
The one thing I would say as a caveat is it's not just about making the offering, but it's about being able to educate about and sell the offering. Because you have to understand that you're selling a change here, right? That part of this is creating the alternative, and then part of it is defining it and managing the change, right? So much of this is about change management, both internally and externally. So it's not enough just to create it. You have to then define it and sell it. There's another book that I use for reference a lot. It's called The Profit Zone. This is another mid-90s book. It's written by, I got it sitting right here next to me. It's written by David Morrison and Adrian Slowatsky. And do not ask me to spell Adrian's last name. I've never met him. I love his book. So Adrian, if you happen to hear this, and David, love the book, talk about it all the time, give you guys credit for it. It's great stuff. There's a hierarchy in that book on strategic control points for relationships. Cost disadvantage is obviously like a 1. You're not in a good position there. Cost parity is like a 2. Cost advantage is maybe a 3. It's just not to try and undercut somebody else's rate. And this, to look back, when law firms are focused on the rates, you're just arguing over cost at that point. So your strategic control is very, very minimal. When you can move up is when you can do like a first mover advantage. So think of the first time the golden parachute was written into a contract. Okay, that's a first mover advantage. In industry, first mover advantage can be years long. In legal, it can be days long, because once a document is public, everybody else is going to know how to write it, right? Very little about, deal making or briefing or whatever remains proprietary for very long, because all this stuff gets publicly filed at some point, right? So this idea of a first mover advantage in legal is very, very minimal. So
I
if
see
you're
where
going to
you're
be
going with this, but I do have a question for you.
Yeah.
Which is because the way that I 100% agree with where you're going, and I think the prompt engineering skills, at least right now, right? Because I guess we'll see where Gen AI goes. But if I'm able to deliver the value at a lower rate faster, right? Because some of the times just the speed of it is what's valuable too, right? And I might be able to make more in less time than if I build my time, which goes back to your earlier example. If I can
Mhm.
solve this problem for you, it's worth $1 million. I'll do it in 50. I can do it in 15 minutes. That the ability to leverage these tools to get high quality results fast for your client, like there
Yeah.
is the value. It's one thing to lower your rates. It's another to lower your rates in a way, right? If you're talking about time, but to increase the value for it's really, I think it creates the inverse relationship between time and money at this point,
Yeah.
right? If you're a lawyer. So use the
Yeah.
AI, get the results high quality faster. So your ability to leverage these tools, that's the extra value that you're giving your clients.
No, there's absolutely that time value of money aspect to it. Sticking with that hierarchy of strategic control points, there's a first mover advantage in coming up with some of these AFAs, but there's also the ability to then set the standard, right? Like if you can set a definitional standard of this is how this should be done. I said, talking about metrics that you may be providing to corporate counsel to say, okay, when we look at what we do for you and what GCs typically want to be reporting back to their boards, here's a set of metrics that we've created for you to help tell the story of our relationship and how we're helping to move you forward in terms of your board priorities. And by the way, we'd love to know how we rank compared to your other law firms on these metrics. A good thing to hear is to say, well, I mean, it's perfectly fine to hear, well, here's where you're falling behind and here's where you're good. Okay. That's a perfectly fine thing to hear because then you can go back and say, well, then let's work on the areas where we're falling behind and let's work together on that so that we're improving your performance because it shows an investment, right? It's also great to hear you're exceeding everybody else on all these metrics. That's wonderful to hear. The best thing that you can hear is, I have no idea how you compare to anybody else. We've never seen this from anybody else before. Because now you've defined the standard, right?
Right.
So to me, when we talk about pricing, this idea of being the one to set the standard and define how different types of legal work should be priced, that is an opportunity to create a 10 out of 10 on the strategic control index where you're literally owning the standard. You own the brand. You are Kleenex. You are Band-Aid. Like you are the name that goes with that product in perpetuity. You are Coke in Atlanta, right? I first time I ever went to Atlanta, I was amused as all heck because, what can I get you to drink? I'll have a Coke. What kind? Pepsi. Like it brings your brain to a stop, right? But they own that standard in that area, So how do you set that standard? To the point about, can we lower our prices and still make more money? That's really antithetical to the way law firms think, right? Like think of the media coverage that would come from a law firm cutting rates. I mean, you catch flack as a law firm if you're seen as falling behind the current pace of rate growth. If it comes out that you grew your rates at 6.5% and the market average was 8, people are wondering, well, why are they falling behind? If you were to actually take your rates negative, but you can't do it on an hourly basis. You have to completely shift the standard here and say, we're not caring about the hours. We're going to say, this is what this thing costs. And you're creating like a menu option. And it's not necessarily going to work for everything right out the gate. But the idea of, I've used an example before that the number one segment of law firms that's utilized by the Fortune 50. So these are the 50 biggest companies in the world. The number one segment of law firms that they use for US based litigation is law firms with between 2 and 15 lawyers. Like when I found that out, we were looking at different data sets and we were testing to see, you sort of have this theory, well, big company works with big law firms, right? It's a fait accompli. No, not even close. The big law share of litigation peaked in 2020 and it's been declining ever since. 2 to 15 lawyers, that's the sweet spot for litigation. When we think about it for the type of litigation that they do, that makes sense. And I've told various people this, and I get a very common response, which is, well, yeah, but what kind of work is it? And I thought, that is entirely the wrong question. One, it's kind of dismissive.
Mm-hmm.
Two, does it matter? Because if you can do that work and do it profitably, does it really matter? Every consultant's got their 2x2, right? They're for it. Well, to me, it's a question of, is it core and is it profitable? If it's core and it's profitable, it's work I want all day, every day, 100%. If it's not core and it's not profitable, I don't want to be doing it. If it's core and not profitable, well, I want to make sure I want it then ranked on just how non-profitable it is, because I don't want it to be a sink. Like if it's core where it's really central to our identity and it's a great feeder engine for us, as long as it's feeding other profitable work, fine. But the area that I want to look at is non-core but profitable. That's this type of work, right? So yeah, maybe my big law firm isn't doing slip and fall work for Walmart, for example. Okay, fine. But why not? Like if I can do those, if I can say, right, Walmart, we can do these at scale. We can do them at $7,500 a crack. I'm making up a number there, right? But we'll do these for $7,500 a crack. And we've got the processes in place where we just churn these things out, right? It's the same model that the PI lawyers on the other side are working on, where they know they're pretty much getting a third of cost of litigation. So every one of them is worth between $3,300 and $5,000 a piece, because they'll settle for between 10 and 15 grand, most of them. And they just churn them out the door, car accident case after car accident case. The more of them I can do, the better. That can be incredibly profitable, especially if you can build efficiency of scale. Well, there's no good reason that a large law firm can't do that. Small law firms are already looking at it. So if you want to be able to compete, big law firms are going to get pinched in a very short order between smaller law firms that are using Gen AI and alternative pricing, price advantage, other things that are making them more competitive. A small law firm today can use Gen AI to operate at a scale that 2 years ago would have been unheard of. So they're going to be pinched from below by firms that can compete up and punch above their weight class. They're also going to be pinched from above, and not necessarily above, but certainly in their same weight class, because the big four is making tremendous pressure to codify alternative business structures in the US. So if these big law firms don't figure out different ways to compete, they're going to be hit on both fronts by these smaller firms that are punching above their weights, and by these huge businesses that have hundreds of millions of dollars of sales quota every month for their legal teams. It's going to be an incredibly competitive environment. And we're not there yet, because smaller firms can't compete at that scale and the big four can't play in that arena yet. But once those floodgates open, we need to start that work now.
Yes.
Because if we wait for the floodgates to open, it's far too late to start building the dam.
Yeah. So I just want to point out to all my listeners that, this is coming from the perspective of somebody who sees a lot of the data behind the scenes. I've been saying this in my CLE that I give on why law firms need to start using the subscription model for at least a couple of years now, because absolutely right. Like, it behooves us as like the monopolists of legal services to change our model so that we could serve more people at scale, probably make more money, but then we reduce the likelihood that these alternative business structures are even going to be approved, because the main reason they're being approved is because there's lack of access to justice, which is a whole other problem that, if you help people avoid problems, are you helping them with access to justice, or do they never even need justice in the first place, right? So there's that part of it. But you're solving this access to justice problem, or closing the gap, let's say, not completely solving it. Sure. But then also, you're not going to get, you're going to get fewer complaints from raising your billable rates again from these institutional clients that have a lot of power and sway in Washington. So I think it behooves us as a profession. And then if that comes anyway, we'll already be running streamlined, efficient, automated practices that are still delivering quality legal services. So I think it's really important. I can't agree with that prediction more. And I'm just glad to see that I'm not the only one who thinks that it's a must change for us, for law firms to do that. One other thing I want to example, another high-profile example, Bill, is I always forget how to pronounce the firm name, but the Twitter lawyers, when they sued Elon Musk, right? Watchell, I think.
Oh yeah, Wild Gotchall.
Yeah, they weren't billing time. They had an alternative fee, and boy, was that profitable for them, huh?
Yeah, putting that Twitter acquisition deal through. I mean, they did it fixed. They hit their performance targets. It's really hard to argue with. Although you look at the recent rulings out of Delaware on Elon's compensation package, similarly structured, and that seems to have a different outcome, at least at this point. So Not necessarily a guarantee, but no, I often, there's a general manager within Thomson Reuters who uses a phrase, and I've sort of co-opted it, but he talks about you catch the fish in the ponds you fish in. So are you targeting the right species? Are you hitting the right baits? Like, are you fishing in the right seasons? All this matters, but you have to meet people where they are. So the idea of a law firm today not marketing online, well, like, what are you doing? Everybody shops for everything online. You need a new pair of shoes. What's the first thing you do? You go out and look for them online. My kids, they're literally being delivered this afternoon. My kids wanted new comforters for their beds. So we went out and bought them online. We didn't go run from store to store to store to store to store and comparison shop like we would have 20 years ago. We're doing it online. And we ended up buying from the same retailer we probably would have bought from brick and mortar, but our style of shopping is different. So this idea of, you know, like it would be antithetical to anybody's marketing strategy to say, oh, we don't need to do that online stuff. No, everybody knows you need to. You think about everything else that we buy for the most part, there's so much that's moving to subscription. I mean, you can buy subscriptions now to shaving products, to fresh meat, to your groceries, fresh produce. I mean, you can buy a subscription box to irregular produce if you want to. Like, there's subscriptions for everything.
Right.
So it's not that people don't think this way. It's that we as an industry haven't done a good enough job of selling the value behind it.
Mm-hmm.
But I tell people when I talk about this, and I talk to a lot of law firms about alternative fees, subscription models in particular, to say, look, it's not to say this is the subscription cost and now you're locked into this forever.
Right.
If you're savvy about it, you're tracking data, because a subscription model not only creates guaranteed revenue for you and guaranteed cost for the client, but it also creates ancillary and upsell opportunities if you're doing it right. And I know I'm not telling you or your audience anything you don't know, but this is a conversation that I have with a lot of people where you're saying, all right, we're going to do 10 of these matters a month for you at 10 hours per matter. Oh, well, let's go back and look at the end of the year, on so many matters, out of 12 months, 10 out of 12 months, you exceeded the 10 matters, and 80% of the time you went past 10 hours on the matter. So you had a lot of ancillary. Let's wrap that in to your subscription cost and make your new subscription cost this. So, we're going to up the number of matters. We're going to up the number of hours. Your new subscription cost is this. Well, you haven't eliminated your ancillary and upsell. You've just gotten a year's worth of ancillary and accomplished an upsell, and still have ancillary and upsell opportunities. And as long as you're driving good value for the client on this, they're going to want to keep using you because it's in their best interests. As long as you can define to them what is that people call it a value wedge. Why is it unique to you, important to the client, defensible from your competition, in a way that makes sense to them and shows them that they're getting the important part. They're getting that quality work product in a timely manner at a predictable cost.
Right. I think, I mean, this might be somebody's first episode they listen to, Bill. So I'm really glad you did talk about things that my longtime audience already knows all about, all those things. And so something I found personally in my practice, and I'm finding this more and more with other lawyers who are using subscription, is some countable metric that's better than time is still something that people kind of like to do. So for example, my entry-level subscription pricing is $20 a month, $50 a page. And I get this question all the time. 50 for drafting and 50 for reviewing. Yes, it's just $50 a page. Let's keep it simple. The simplest meaning, right? And so we're counting pages. So think about it, the Costco model, right? You're a member, you're a subscriber. You want to maximize your subscription benefits. So when you're out of something or you need something new, where are you going to go? You're going to go to Costco because you're a paying member. You're getting discounts there. So you're getting below market or flat fee rates at the law firm you're subscribed to. It's only $50 a page. That going in. So instead of waiting for the output of how much it's going to cost, how much it's going to cost going in, but you're still counting pages. What I do for my higher level subscribers, my business clients who they have a frequency of business where they know they have so many contracts a month, counting pages is nonsensical for them. So we count projects instead, 10 projects a month, right? And we don't count pages. Some projects are 3 pages, some are 20 pages, but you know what? I'm leveraging automation and AI tools, and we're going to get the work done as quickly as possible. And I want them to maximize their subscription benefits so that they stay subscribed, and it's month to month. I don't lock them in, because then it incentivizes that back and forth relationship, and I have to be providing value every month. So it's one of these things where I think it still feels good to count something, and you have to scope it some way. and I don't know what you've seen other law firms doing, but who are trying to do some version of this, but I have found either counting pages for a la carte work or counting projects for more frequent work has worked really well for me. And this, granted, this is only 2 years of doing this kind of a thing.
Yeah. No, and I mean, I've seen both of those models employed at various firms. The project slash matter model seems to be very, very popular, and how you structure it can be very creative. It depends on the type of work that you're doing. So the upside of it is it allows for a lot of creativity and a lot of mutual benefit. The downside potentially, just to kind of not to throw a wet blanket on this, but just to understand the market that people are playing into. If you're in an RFP situation where you're looking at competing for either a panel spot, it's a law firm or a law department that has a more traditionally defined portfolio of work. Something like that may not play because it's going through the procurement department and it's not going to fit the four corners of what they're looking
Right.
at. And that then goes back to the GCs to say, all right, well, 54% of you are saying you want to be using more AFAs. That's going to involve some creativity, and your current procurement process doesn't provide for that. And in some instances, the GC has control over that. In other instances, the GC doesn't. It's being mandated on them sort of at an enterprise level. So
Right.
I think a lot of this too is going to involve a high degree of attenuation on the part of the lawyers, where, this idea of we have one rate that we charge for every timekeeper of every class, every timekeeper of this class charges the same rate for every client, for every matter, for everything, everywhere in the country. That's probably not going to work. Same thing with, well, this is our subscription model. This is how we do it, where I charge X per month and X per project. Well, that may not work for every client. You have to create some differing alternatives. And I think this is going to loop back to a part of the conversation we had earlier when we were talking about, lowering your price. Well, there's definitely going to be work where we can lower the price, make it up in volume. I mean, I still have to be able to turn a profit. When I lower the price, it still has to be profitable. Because if I lower the price to a point that I'm now in negative territory on it, you don't make money by taking a negative number times a positive number. You just get a bigger negative number, right? So I
Right.
still have to be profitable. But you think about General Motors, the same company that makes the Chevy Cobalt makes the Cadillac and the Corvette, right? So you've got a low margin, high volume car and a very low volume, but high margin car. I mean, truth be told, it doesn't take that much more in terms of resources to produce a Corvette compared to a Cobalt. There's a lot more engineering and stuff involved, but the actual cost per unit, like, you're not
Right.
talking huge differences. You don't sell a Chevy Cobalt for 120 grand. You'd never be able to touch a brand new Corvette for 30, right? So you're creating a product pyramid. That's going to be incumbent on the legal industry as well. Is how do we then start to tier? How do you push where there's mush? How do you find I'm going to call back to the Morrison Stolowski book, The Profit Zone. That's what they define as a profit zone, is where is the area that the client will allow you to make money? How do you identify that? How do you exploit that? That's going to be something that lawyers have to do. And the subscription models can change based on what I'm doing. If I'm doing one type of work, you've already got two different zones set up, right? Where you've got your consumer clients where it's $20 a month and $50 a page. And then you've got your corporate clients where that doesn't make sense. So you're doing it on a per project basis. You've identified two different zones. Well, now as you start to refine into the corporate clients, how does that zone vary based on the type of work or the type of client or the industry or even the individual client? Can I tailor things to work for an individual client so that I can get through an RFP screen, for example?
So I can answer that question, but first I want to check on time because I have more time. We're technically at time. Do you have a few more minutes?
I've got a few more minutes.
Okay. So we'll answer this, we'll address this, and then we'll move into my last two questions I ask all my guests. So the way that I'm handling it is actually I'm not going through like RFPs, and I do have I have just a very few amount of clients who have used big law firms, like big law firms, but I'm doing their legal work that is unsexy, vanilla, everyday stuff that they're happy to offload on a predictable monthly price, that it would be stupid for them to have these top firms billing at their billable rates to do these types of things. like everyday MSAs, equipment lease agreements, some low-level hanging employment things that haven't gone in front of the EEOC, or, just settling and resolving disputes with customers, all these types of things. So they don't want to pay $1,000 an hour for that type of work, because it's not really, it has to generate them, a large amount back for it to make sense to do that kind of a thing. And the risk level, they're comfortable with a medium amount of risk. But now for a reasonable monthly price, they can start offloading that stuff to me. And I'm sure over time, though it's yet to be proven, I will start to get some work that would have gone to the larger firms. And it's not because I won out in an RFP. It's because I'm helping them with daily vanilla stuff that you can't charge a lot of money for, legal work.
Yeah.
And I'm developing a relationship with my clients, and they're going to have me work on that next M&A transaction, right? Even if I'm working as fractional in-house counsel with outside counsel, kind of a thing. So I think that's the way that you slot in. And those are these small firms. I think that's their opportunity to come in and be these small firm, lower cost competitors to big law. That's my response to that. And we'll get your response, and then we'll wrap up the show.
Yeah, no, I think you're right. I mean, and again, that's something where for the type of practice you're running works absolutely great. Would that work for a mid-sized law firm of 30 lawyers? Well, maybe not. It all depends on the type of work that you're going after and the type of relationship that you're having, because there's just certain things that, I mean, if you're trying to say, we want to get on a panel with, a Fortune 100 company, that's going to be really difficult with the way a lot of those RFPs are structured, because you're going to have to do the RFP. There's just no way around it. So it's understanding, who are we, what are we offering, what are we trying to win, and how do we win that? And finding that and tailoring an offering that's going to meet that. Because frankly, you've got to know your customer a little bit, right? I tell law firms all the time, look, if you walk in and you've got a GC who is, much the same mindset as I know you are, where it's like, I don't want to do the billable hour. And you say, we're going to give you a 30% off or 30% discount off of our standard rate. You're not winning that business, because you're not speaking to that client in terms that matter to them. Alternatively, if you've got a GC whose board only cares about, well, what's the discount that we're getting from outside counsel? If you go in and say, I've got this revolutionary fixed fee, here's all the benefits, it's a beautifully refined system, and it's mutually beneficial, there's great value, you will not win that work, because you're not speaking to the client in a way that speaks to them. You're better off making up a rack rate, knocking it down by 70%, and charging what you would have charged in the first place anyway. Because then they come back and say, hey, we just found this new law firm that we're getting a 70% discount, because that's the number that they need to report back. So it's knowing your customer and knowing how you make that sale. That's a long-term process. But again, it's that idea of, how do we identify the zone where we're able to win that business and make that profit? And that's going to vary from firm to firm, and really even from client to client. It's not a one-size-fits-all thing. If you can create a model that works well for you, your $20.50 model, that is not going to work for a lot of clients, right? But you're not selling it to them. You can sell that to the people that want to buy that type of a service. It's as you get into that higher echelon of client, where things get much more bespoke, it gets a lot more complicated. So it just becomes a question of, look, what type of work do I want to go after, and what type of work can I do with my model, what model or models profitably?
Well, I'll tell you one of the ways I keep clients, because I have business clients who test me out at $20 a month and $50 a page. And I get them signed up for more because they realize they could save money at paying for projects instead. But one of the ways I keep my clients subscribed to me is it's a one-time payment. So I'm not going to charge you again if we have to look at this document again. So if it's a commercial lease, you pay me up front, and now you're staying subscribed. I'm doing all your other legal work because you're subscribed to me. You still have your Costco membership card. So I'm doing all the other legal work. So I don't need to charge per page again on that document. I drafted it, or I already reviewed it and negotiated it and redlined it. I know that document. So I don't charge again for that. So that's how I keep them subscribed. And so I'm getting all their other business. To go back to your fishing analogy that you said your boss likes to use, or somebody likes to use, I like the apple analogy, where it's, okay, I can look at this client for this one matter. I get one bite at this apple. I'm going to take the biggest, juiciest bite I could bite. With the subscription model, you're thinking about lifetime revenue, and you're thinking, I want to eat this whole apple. It's just going to be over time. right? It's going to be over time. And I might do things I wouldn't normally do in the one bite of the apple type strategy that, would make it so I get less of a bite in that instance. That actually helps me bite the whole apple in the long run. So that's the
Yeah.
way that I think about it. But so, I mean, we're going to have you back on the show because I feel like we keep going for another hour easily. My call to action is for my listeners and for you, Bill, once this episode is live in a couple of months, to share this with all your legal ops and GC friends and family and colleagues, because this, I mean, to me, what this interview highlighted is, I think from the customer side, from the institutional client side, if we want to see disruption, I think we need to persuade them that you need to do the RFPs differently. You need to be willing to give up the sunk costs that have gone into creating these processes of evaluating attorneys, of deciding who goes on the panel or who gets hired. And that's what I'm going to ask of my audience and my listeners, is to share this with those people. Because if we could change their minds, then I think we're going to see lawyers, be required or have at least the ability and the flexibility to adapt. But with that, Bill, I want to ask you the last. So we're going to find out where we could find you in a minute here. But first, the last question I ask all my guests is a hot dog a sandwich, and why?
My 13-year-old daughters, I have twin 13-year-old daughters. They literally asked me this question last night.
So you're ready. You're ready.
I'm going to go with the lawyer answer. It depends. I mean,
of course. But if you had to choose,
I got to go with no, and I don't have a real good reason for it. I don't know. To me, it's something different. My daughter, Abby, I think she had, one of the better explanations. You don't eat a sandwich from the end, and you don't bite a hot dog from the middle. Like, okay, it's a process question for her. And I think, I've always said Abby, I think, is going to be my engineer. And to me, that's a logical answer, right? I've never bit a sandwich from the middle, I've never, bitten a sandwich from the end and eaten down the length of the thing. And you don't eat a hot dog from the middle. Like, you wouldn't hold it sideways and eat it from the middle out. So I'm like, okay, that makes sense to me. What a hot dog is, I don't know. We'll call it an alternative. We'll call it an alternative food arrangement.
Oh, I love it. Two unique answers to that question today. So Bill, if people want to follow up with you and reach out or listen or read any of your stuff, where's the best ways for them to do that?
Yeah. So all my stuff gets published at thomsonreuters.com/institute. That's the main page for the TR Institute. So not just my stuff, but everything the Institute puts out. It's all there. It's all free. We don't make people pay subscriptions. Nothing's charged for. It's great because I'm not. And I would say too, for Thomson Reuters, our stuff is not. It's totally product agnostic. We're not pitching any of our products. So you're not going to be getting bombarded with TR sales pitches. That's not what we do. We're the thought leadership engine. That's our mandate. So I'm not tied to sales, marketing, anything like that. So at thomsonreuters.com/institute, I put a ton out on LinkedIn. You can just Google either Bill Josten or William Josten. I get a ton of results. My author profile comes up first. My LinkedIn profile comes up second or third. A lot of stuff goes out on LinkedIn. I'm on Twitter/X at WJ Josten. Or I'm happy giving out. TR emails are very formulaic. william.josten@tr.com.
Great. Thanks so much for coming on the show.
Thanks so much for having me. I really appreciate it.
And that's our show. Thanks again to 650 and Gavel for being sponsors. The best way for others to discover this show is for you to share it with somebody you think would find value from it. Follow me on LinkedIn, since that's where I'm most active on social media, and click the bell towards the top right of my profile to get notified about all of my posts about this podcast and everything else I think is valuable for you to see. To get in touch, message me on LinkedIn or email kurbis@lawsubscribed.com. All links are in the show notes. Until next time, this is Matthew Kurbis with Law Subscribed.